Good afternoon, everybody. It's 14 hours on the clock. It's the 4th of November. We are now entering the final session of what has been so far a most wonderful conference. Virtual as it has been, certainly there has been no compromise as it pertains to content. We are in plenary session 3. I'm the moderator, Songezo moderator for those who have just joined. And not long from now, towards the end, you will also be again introduced at the same time, bid farewell by my co-conference moderator in Miss Nandi Mokwena. Until 3, for this hour, we are talking about consumer protection and competition laws, a convergence. What can we learn then from the COVID-19 pandemic and other recent enforcement measures that have taken place? Here's the background to the conversation and a little bit more about the conference speakers on this segment. After this, price gouging behavior stemming from the pandemic and the enforcement against such conduct on the back of competition law has come into criticism, with many pointing to the consumer protection laws being arguably more appropriate. Many of the jurisdictions, of course, have both competition and consumer protection laws in the same act and dealt with by the same regulator. Not in South Africa. Other consumer issues like data privacy, protection are also beginning to intersect with competition law more and more. This session then would explore these issues with the perspectives of other jurisdictions where both laws are in the same act alongside the South African experience. To simplify it, if you keep receiving 021 numbers telling you to go and vote for this political party, or 087 numbers from people you've never met and probably never will meet, asking you 5 minutes of your time, consumer issues, the regulation of information, for, of course, competition advantages in commerce. So this session is probably the one you are really going to be interested in. Let me then welcome conference session moderator in Yasmin Karim, who is at the Competition Tribunal of South Africa, together with her fellow panelists. More about them from Yasmin, but Tezi Mabuza, Amelia Fletcher, Sizwe Kamtuze, as well as David Howarth. These are your speakers and panelists for the session. Yasmin, good afternoon. Welcome.
Good afternoon. Thank you, Songezo. You've done such a brilliant introduction. I think you've done the job and we all can go home. Welcome, everyone. Thank you, Songezo. And I want to welcome both my panelists today. I hope you can all hear me and see me firstly. And let me welcome to this panel, the Acting National Consumer Commissioner, Tezi Mabuza. Please, could you put your video on so that people can see you? Hello, welcome, Tezi. Professor Amelia Fletcher from the UK. Thank you so much for participating. David Howarth from Australia is a practitioner there. David, can put your video on so people can see you. And then Sizwe Kamtuze, who's at the moment serving as a part-time commissioner on information regulator, but was also a practicing attorney. Welcome to you all, and if you can put your videos on so that people can see you, and of course, leave your microphones muted. Welcome, David. Welcome, Sizwe. Wonderful. So just by way of context, you heard what Songezo's roadmap was for our session, but let's just recap where we were. We know that excessive pricing and what I would call exploitative pricing has been with us forever. You know, wars, natural disasters, and pandemics like COVID-19 always give rise to opportunistic exploitative practices, either in the form of excessive prices or in the form of hoarding for scarce goods. And this is not something new. However, what is a matter of controversy is whether competition law should be enforcing what we call excessive pricing in the context of situations like natural disasters. Of course, excessive pricing has always been in the South African law and certainly in the EU and the UK and Australia, but not in jurisdictions like the US. So we have a range of jurisdictions across the world where jurisdictions take different approaches to whether excessive pricing should be enforced as a matter of competition law. Of course, the conditions that enable excessive pricing from a competition law perspective are what we would call market conditions. And these would differ from the metal type, where there's a monopoly supplier of a certain good, or a natural disaster or a COVID-19 pandemic, where a crisis leads to excess demand. And the market conditions are not the same in every case of excessive pricing. Nevertheless, the controversy is still there, with some people saying, well, it should be a matter of consumer law and consumer protection, and others saying it should be a matter of a unique piece of legislation that deals specifically with those issues. Now, in South Africa, what has happened in the context of COVID-19 was a declaration of a national disaster, state of national disaster, and regulations that were promulgated consequent to that. Many countries also had regulations promulgated. For example, in the US, there was a federal executive order that said price gouging should be regulated in the context of COVID. This was also recently. So South Africa is not unique in the sense that we decided to intervene as a response to rising prices of essential goods such as hand sanitizer, surgical masks, and certainly certain food items such as rice and other staples. In those regulations, the enforcement of this conduct was allocated to both competition agencies and the Consumer Commission. Competition agencies, of course, had done their work. The Commission was inundated with hundreds of complaints. The Tribunal has released 2 decisions, Dischem and Babalegi, but to make a note there, mental note, that those were not decided in the framework of the regulations, but were decided in the framework of the existing provisions of the legislation, where the judgments are there for everyone to read, but the Tribunal took the approach that under the excessive pricing regime as an abuse of dominance, one could infer temporary market power and enforce this conduct in unique circumstances such as the pandemic. Now, given that background, let me first turn to Tezi. Tezi, we have heard very little from the Consumer Commission, and I'm very pleased that you are here because you can tell us, to kick off, whether you have been inundated with a similar number of cases as the Commission has, how you have dealt with that, approaches you have taken, and the challenges that you might have faced.
Thank you, Yasmin, and thanks for the opportunity and the introduction of the subject. Yes, the National Consumer Commission worked closely, actually cooperated with the Competition Commission. What we were dealing with this essence, that the argument is with price gouging with consumer, but from our side, in our experience, it is wherein we saw a lot of cooperation. When we are looking at it, where it's in a market system, you are looking at the law of and supply, where in the consumers really determine actually the rate at which price will escalate or will spike. But in the case now, because what's happened, the freedom of the consumer to choose supply, to select where they want to buy the geography, and all that was saved by freedom actually to move around, select their price through the. So what we saw is that there was that disruption in the market, but what led to now you saw the demand and where in supply really took advantage of it. There was the intervention of the state. So the role of the Consumer Protection Act is that we protect consumers against what we see as unfair, reasonable, otherwise improper trade practices where advantage is being taken. But then in this case, it's not only about the advantages, wherein you see that the practice in the market would exclude a particular sector in the market. In this case, people that were of low income in far-flung areas and were because the price spiked to such an extent that they really could not afford those goods. And in this case now, what it as the National Consumer Commission make it easier to set up a toll-free number, those ourselves and the competition. We shared those cases where in now
sorry,
when we look
Tizzy, sorry to interrupt you. We're just having a slight difficulty hearing you. I'm not sure how the others are receiving you, but we're breaking up quite a lot. And perhaps, I mean, if you have a connection bandwidth issue, then you could switch your camera off. It's more important for us to hear what you're saying.
All right, that is what I will do. I think switching off the camera will assist. Yes. What
much better.
Yes. What happened is vulnerable. What we had to do, we looked at the demand side of the consumer interface, but we realized you spoke of the met. What we saw is that when at the supply side from the consumer side, we dealt with a company that was called Belechi, which is a company subsidiary or a sister company to Babelechi. So when we actually investigated, it pointed upwards to say that it was not only them, it was also the supplier, their supplier, which was Babelechi. So in this case, we saw that kind of like a complementing of each other, with the consumer interface, wherein the problem will direct saying that the manufacturer is responsible. It's where competition commission comes in. So this instead is not actually a once-all to say that it's for the consumer protection or the competition commission. Actually, what we are seeing is that both areas are actually now, in this case, relevant. If controlling the demand side, I would like to see, check the supply side. It's not really the one. So for us is that both the Consumer and Consumer Act and the Competition Act, they are both equally applicable, because what they will do is in the competition side, competition is there to ensure that prices that are being offered are competitive in the interest of the consumers. While in the Consumer Protection Act, it was to ensure that those prices, they are fair, they are reasonable, and they are just. So that is what we saw or what we learned during this pandemic. Thank you.
Thank you, Tezi. I mean, that is quite an interesting dichotomy already, where you've got two standards. One is, as you said, Tezi, that we must look at effective or efficient pricing. On the one hand, that's a standard for us, and I'm sorry I'm saying us, but I do come from the Competition Tribunal, and for you, as a Consumer Commission, is fair and reasonable. And I would think that somewhere the truth must lie somewhere in between. And maybe Amelia, you can help us out here. I mean, the UK CMA was very positive about the tribunal's approach in the Babelegi and Discam, and was encouraging of the Competition Commission's enforcement of those cases. So it would be interesting to hear from you, both in terms of your serving on those bodies and your expertise, but also what the framework was in the UK and the experience, particularly in the context of the COVID-19 pandemic.
Thanks, Yasmin. Well, I mean, yes, we're lucky in the UK in that we have the competition and consumer powers all within the CMA, which means that we didn't have to decide which body was responsible. The CMA was effectively responsible. We did still have to think about which powers we might use, and that wasn't straightforward. But what we were able to do was kind of before that, the very useful process of just trying to work out the size and extent of the problem and where to focus. And actually, I think one of the things that, so I think we did quite a lot of good good things. I think we did have some significant constraints, and I'll mention them in a minute. But we immediately set up a COVID task force so that we could do real-time monitoring and reaction to the issues arising. Actually, it was really interesting that Tazy said that she set up a call center. We did invite calls initially, but we got 2,500 complaints within the first 3 days of having that call and email center open for about 1,300 different businesses, which was actually undealable with via calls. So actually what we developed very, very quickly was a digital form so that people could actually fill out a form, and it was much more easily analyzable. And that was a really good call, because by the peak of the complaints, we were getting about 16,000 a week. So it was really, couldn't have been handled by a reasonably sized call center. What we also found was that while many of the complaints, and particularly initially, were about price gouging, actually, after a few weeks, that had fallen away dramatically, and most of the complaints were then about cancellations and refunds, particularly in the area of holidays and travel, which is more squarely within consumer law. But what was nice about having this single line was there was a very easy morphing between the different types of complaints. It was the same line, the same form, and we could just watch how the mix of complaints was changing. Nevertheless, there were many thousands of price gouging complaints. And what the CMA first of all did is did some analysis of actually what categories of product were the biggest complaints arising in, and what was the scale of the price increases that we were seeing, because we actually asked for that within the form, and so we could very quickly analyze it. And we found that the highest price increases were for hand sanitizer, where the median price increase of around 400%. Then things like paracetamol, flour, fruit and veg. And hand sanitizer was also the most complained about product, so 20% of all price complaints. So it was really useful in terms of focusing then, okay, what do we do? And then in terms of what we did, there was a set of steps. So the first was, we literally just thought, economically, is price gouging a problem, or is this just the market working via price to allocate the products to who needs them most? And lots of people said that's what's going on. Actually, we took a different view. We thought that this wasn't in this particular situation of emergency with essential products, just as Daisy had said, this wasn't the normal market working well. This was price gouging that was going to have significant detrimental allocative harm to consumers. So it was worth doing something about. Then we looked at whether the price rises were significant on a market-wide basis. So we looked at Nielsen data, and actually we found that they were cross country. The whole country was seeing these price rises. They weren't just local in little local areas. So then we thought about what law applied, and really we didn't think that there was much that we could necessarily do with consumer law. We were inspired by the South African reaction in dealing with it with competition law, and that is essentially the route that we took as well. But we thought that would be very slow, very hard, and it wasn't even obvious that we could make it apply, given that actually we were seeing these price rises across lots and lots and lots of very, very small players, and we have to show abuse of a dominant position. They could all have temporary market power, but to bring all of these cases against all of these small players felt complex and difficult. So we actually publicly advocated to our government that we wanted a new price gouging law, which would be specific to these sorts of situations and essential products. They do have these sorts of laws in many other parts of the world. So we thought they would be useful. I'm afraid we failed in making that case, but we are still making that case for this situation in the future. Despite we had a very difficult balance to make, because we wanted to say that we needed new law, but that the competition law did still apply in order to try and focus minds, but we just about ran that line okay. So what we also then did is we were really transparent about our analysis. We published where we'd got to every week. And we also did a lot of advocacy. We wrote a joint letter with the General Pharmaceutical Council to 4,000 pharmacies and letters to 26 trade associations, setting out our expectations for really how businesses should be behaving. We engaged with online platforms like Amazon to point out complaints in their space and say what we expected them to be doing. And that was actually very fruitful. But then finally, we did do some law enforcement, because we thought if we're going to shout about law enforcement, we have to do some too. So we did start 4 enforcement cases against 4 pharmacies and convenience stores, all in relation to hand sanitizer. That said, they have all now been closed, and the case closure notices are not definitive on whether we thought there was or was not a breach of the law. They were closed on prioritization grounds because essentially they'd all now reduced their prices again, and the issue was gone. And we thought that we couldn't justify taking those cases against small firms on the basis of the relative lack of consumer harm going forward. But so we still don't know whether the law would or would not have applied, but we still feel that it wasn't the best tool for addressing this sort of short-run emergency price gouging. Thank you.
Thank you, Amelia. I think that was a sentiment that was often expressed in relation to our enforcement decisions, choices in relation to Dis-Chem and Babalegi, that competition law should be looking at systemic effects and shouldn't be dealing with thousands of individual cases. However, in the absence of a tool, and certainly in the context of a pandemic, particularly in a very unequal society as ours, the Commission and certainly the Tribunal took the approach that this was the best tool. Not to mention that we, of course, were required to do it under the regulation, and I mean, this has not come up before, but the legality of that regulation was going to be challenged at some point by Dis-Chem certainly raised it in its papers. And people said, well, actually, you can't do this through regulation. You have to do it through a particular law of Parliament, which is where I think you were looking to see. But your approach of advocacy combined with enforcement is very impressive, and it's something quite remarkable, especially the lessons about using digital methods to manage volume of complaints. David, have you in Australia, and you're a practitioner, had any direct involvement with managing this kind of complaint in the COVID pandemic? Or what is the legal framework in Australia, by the way?
Thanks, Yasmin, and hello to everyone. First of all, the question raises a caveat that I should put around some of my comments. I do act for Amazon in Australia and some other online businesses, but what I'll talk about here are my own views rather than a client or the firm. The second thing I would just like to say, in Australia, we have a tradition of acknowledging the country that we come from. It's a bit strange over Zoom, but I would just note that I am in Gadigal country of the Aurea Indigenous people, and I pay my respects to their elders past and present. I think, Amelia, to get to your point about how do you get a tool that allows you to have directed action where there are particular problems on pricing, the answer I think we've found is that you give the minister the power to do that, and that way they have an interest in making the determination themselves. I'll give you very quickly the background, if I may, to the Australian position, and it's in a way a far more conservative, economically rational backdrop that we have. So on the competition law side, our Section 46, which is the monopolisation or abuse of dominance position here, only talks about substantial lessening of competition issues. We don't have any exploitative conduct rules, and that has created some tensions, which I'll come back to as I talk about finding a middle gap, Yasmin, that you described between fairness and efficiency. On the consumer side, we have two laws that have been invoked by our Australian Competition and Consumer Commission, which, like the CMA, is an integrated regulator. Misleading and deceptive conduct rules and what we call unconscionable conduct rules. Now, these are not ideal responses in a pandemic sort of situation. So the public announcements by the Commission on misleading or deceptive conduct has essentially come down to don't mislead consumers about the reason for price increases. And that's fine as far as it goes. But of course, if a business were honest, and many of them are, and they will say, we are just imposing this price increase because we can get away with it at the moment, then there is no breach of the law and there is nothing that can be done under that provision. The other law that we have is unconscionable conduct, and this is sourced from common law principles. It still is very limited, and it looks much more at the negotiation position between the parties and any procedural unfairness rather than the substantive unfairness that exploitative conduct raises. And so, again, there are questions about whether that law can be used effectively. And it raises what I think is an issue behind all of this, and that is that we live in market economies, and a central tenet and principle of market economies is that the market sets the price. And so having this sort of unconscionable conduct law would essentially be saying that it is unconscionable outside the bounds of norms of conduct for a business to charge what is a market price. It'd be very difficult to impose that sort of law on a farmer, for example, if there were a drought and the price of crops of wheat went up. And similarly, we'd run into that sort of situation with a temporary constraint on production. In the past, we have had some examples of specific price control laws, and New South Wales had one that was introduced just after the Second World War. And Yasmin, as you rightly pointed out, it's often in response to crises that we get these laws. That law had not been used very often, and it may not surprise anyone to know that in a sport-loving country like Australia, the time when it has been used was when there were sharp increases in the price of tickets to sporting events, and then the consumer bodies would come in and say this is un-Australian and we won't accept it. I'm not even going to talk about our recent rugby performance with New Zealand, but nobody would want tickets to that, so that may be another solution to it. That law, ironically, was repealed in 2019, and just as the pandemic hit, when it may have actually been useful, and it did allow for the declaration of particular products and for the setting of prices of those products. There has been a proposal by the Labor Party in New South Wales to reintroduce that, but they are currently not in government, and so it was rejected. Where that led us to, and this is possibly one of the solutions, I should first say, Amelia, in response to your comments, our consumer body Choice has also been quite active and hasn't quite had the number of complaints that you referred to, but there's certainly been a very large number of complaints that they've made public on price gouging issues. So we ended up with a determination under our Biosecurity Act, and if you've got a pen ready to take this down, it's the Biosecurity (open brackets) Human Biosecurity Pandemic (close brackets) Human Coronavirus with Pandemic Potential (close brackets) open brackets Essential Goods (close brackets) determination. Rolls off the tongue. I'm just going to refer to it as the determination for these purposes. The approach that it took was first to define particular products and their essential goods, which come down to various forms of PPE, so disposable masks, disposable gloves and gowns and so on, and hand sanitizer. So a very sort of focused set of goods. It then defined the period over which the determination could apply, and that is what's called the pandemic period that's set by the minister. That's recently been extended to December because the pandemic has continued. More controversially, and and what's difficult for us is it defined two qualifications. The first is that the goods have to be acquired in a retail transaction. Now, I've tried to find out, and I cannot discover where that comes from, but it's essentially where there are scammers who are buying products from a supermarket, for example, stockpiling them and then selling them later into the pandemic. That does obviously dramatically limit the scope of the determination. And the second one is that at the end of the day, we have to set a price or some formula that's allowable. And the formula here is 120% of the purchase value. So that really amounts to a 20% markup on the price of the products. And that, to my mind, is a bit small. Amelia referred to 400% markups, and that's the sort of factor that we're looking at with a lot of price gouging cases. 20% markup is quite common in a lot of markets, and certainly that I think would put a lot of luxury goods into price gouging territory. The other interesting aspect to this determination is that it also had an export prohibition in it. So there's a bit of a conflict there. On the one hand, it's saying that there's a constraint, which means that the products can be sold at an enormous markup in Australia, but at the same time prohibiting the export, which suggests that there's actually a better price to be had in another market. So look, there are a few of the difficulties that we run into these determinations. I'm very conscious of the time. That was a particularly sort of practical response in the context. So the government is, and the minister certainly, to be allowed some flexibility coming. But I do think the interesting issues, I think, from a competition point of view are whether we should be looking at ex ante as opposed to ex post responses. I would think that setting up some sort of regulatory system where there's, first of all, a declaration power or a way of limiting it, and then a mechanism for setting a price along a more sort of infrastructure regulation-based approach within an ex-ante context is probably preferable. And the other issue, which I won't go into in detail in this session, but we may come back to, is the role of channels. And as Amelia has pointed out, and I was involved with Amazon in monitoring some of the price gouging activity on particular digital platforms. But I'll leave it there, Yasmin. I'm conscious that we have a lot to get through.
Thank you, David. That is very interesting, and it does raise a particular issue that has been front of mind for me. Is that a pandemic such as COVID-19, I think, came upon governments very quickly, and I think many of them were unprepared for the extent of that pandemic. Had no time to plan, a public health response. For example, and if hand sanitizers would have formed part of a public health response, as do condoms do in a HIV AIDS context, and would be freely available for the public out there, there would be no incentive for firms to raise or increase prices, because the market would be flooded with public health response. But that then also brings us to an issue, because a public health response such as hand sanitizers or supplying those freely to consumers, we certainly in South Africa had embarked on that at taxi ranks and so forth, the public transport nodes and so forth. If that was more widely extended to all populations at every sort of corner or institution or wherever, you would have had perhaps a slightly different response in terms of pricing and less burdensome for regulators tasked with that. But that response of infection control was also in South Africa. The pandemic also raised another issue, which has not been given much attention to, but which is related to, in some ways, and has a nexus to the earlier discussions we had around the digital economy, and brings us, Sizwe, to you, because one of the concerns that came about in terms of the infection control mechanisms utilized by government as a response was the use of mobile technology in contact tracing, where information was gathered about the movement of an individual in order to assist that individual and, of course, government in containing infection by saying, well, you came into contact with the last 40 people, whatever, in the last few days. Use of that gave rise to such an anxiety on the part of citizens, where people felt that data was being gathered and collected without their consent, and they weren't sure how it was going to be utilized and so forth, to such an extent that I think the government was discouraged from continuing with it, which I think was wrong, because I think, it was my own views, it's a very efficient way of tracking your own movements. But it does raise that question, which is, well, what do you do in a context like that, where information, your private information or your personal information is being gathered, maybe for a public interest purpose in this case, and without your consent, of course. And how would you, as an information regulator, deal with that kind of issue, if at all? I mean, is that part of your mandate? Would a consumer be able to come to you and say, I want to lodge a complaint about X, Y, and Z, and this is an invasion of my privacy and so forth?
Thank you very much for this. When the COVID pandemic started, government came out with certain regulations, and these were regulations, in essence, became law. So POPIA doesn't give a prohibition on the collecting of personal information where the law requires same. So where the law says that a particular entity should collect the information, then that would be permissible. That is one of the exceptions to the directly collecting of the information from the data subject. But with that having been said, it raises further issues that once you've collected the data from the data subject, how do you store the data? How do you further process the data? Do you keep it to yourself? Do you share it with other government entities? Are you even allowed to share it with other government entities? And I think the most important issue in terms of data is the cybersecurity aspect. To say, once all of this data has been collected, let's say for argument's sake, the 750,000 people who are infected with COVID, if I'm looking at the stats, right? That information of that 750K people, it needs to be kept safely and secure. So the government department that has been tasked with keeping this information, recording this information, have now a higher duty, not just to not further process the information, but they must now also ensure that their safety and security guards relating to that information is of a acceptable standard. We talk about organizational means and technical means in terms of POPIA. Once this personal information leaks or unlawfully is shared with other people, that is when now you start getting phone calls from people you don't know, people offering you services and products who you've never asked to do. And I think that is the danger of collecting personal information. It may even result, just to put this into context, it doesn't just raise consumer issues in terms of the direct marketing, but it may also raise issues pertaining to unfair competition. What is if one particular competitor now has this database of the 750,000 people infected with COVID, right? What advantage does that particular party have who has got access to that information, let's say from a drug treatment perspective, right? Let's say it is a pharmaceutical that happens to have this information. Because they have this information, they may have an unfair advantage. They may be contacting the people infected with COVID and saying, come get our drug. Our drug is good, it will help you. And in that way, the illegal sourcing of the information, which is, like I said, a data protection issue and a consumer issue, may also end up being a competition issue. I don't think I should say more from that.
I think that you've actually hit the nail on the head. I think that would be a serious concern for us. Of course, I don't know. We certainly are not mandated to deal with data issues directly, but as a matter of competition law, of course, we are. And certainly the issue of security of that information does raise concerns, especially in a country where there might be a degree of stigmatization associated with the pandemic, where people might not want to reveal it to family and friends, and yet it becomes a matter of public knowledge or in the hands of a marketeer. Amelia, you've had experience with this and have some knowledge about data protection and privacy issues. Would you like to have a comment on this?
We do have our own data regulator, and they have been very exercised about exactly the issue that Sizwe was talking about. But actually, at the CMA, there's been a very linked issue, but not COVID specific, which is in relation to the market for digital advertising more generally, and the role of privacy consents in that market. So the CMA in July published its market study into digital advertising, which was mainly looking at Facebook and Google. And one of the key issues was how their market power in digital advertising was linked to the choices that they gave to consumers around privacy, and not only what choices they were really making available, because actually to some extent it looks like there's some choice that you're making, but there isn't as much real choice that you're making. And this is in an area where consumers, despite their nervousness about giving the South African government their data, are quite seem to give away all sorts of data to the digital platforms that is used for advertising. So not only is there not real choice, but the CMA also concluded that the choice architecture that consumers face leads them down pathways in terms of privacy consent that is very much in the interest of the platforms and not in the interest of the consumers, or not necessarily in the interest of the consumers, and not necessarily in the interest of competition. They were also, and this also is an interesting link to what Sizwe was saying, they were concerned that the platforms themselves might be abusing or strategically misinterpreting existing privacy law, again, not to share data with competitors that actually wouldn't be so sensitive and would be allowed under privacy law, but because they were drawing it relatively narrowly, they could keep the data within their walled garden, and that was actually having anti-competitive effect. So I think this link between, this is not COVID specific, but the link between privacy law and competition, I think, is a growing area of focus. And the CMA doesn't do privacy in the UK, but it is working incredibly closely with our privacy regulator on this topic.
So thank you, Amelia. David, would you have any comment on the issue of data protection in the context of pandemics such as COVID-19? I think it does raise some concerns. If people are going to be subjected to direct marketing, for example, funeral plans and pharmaceutical drugs and all, it certainly adds insult to injury in a sense once you have been found to be COVID-19 positive.
Yes, absolutely. And look, I agree with Amelia's observation that people are much more willing to hand over data to private entities rather than governments. There's a sort of lingering suspicion that government must be using it for evil purposes, whereas private entities don't. We've had, just to refer back to Sizwe's discussion, we've had a similar experience with some of the issues around data collection in the context of COVID-19. Our government did release, and has still, what's called the COVID Safe app. Now that was subject to quite commendable debate on privacy protections, and as a result of that, it does work quite well from a privacy point of view. So there are rules, for example, which have been incorporated into our Privacy Act against coercion. So people are not allowed to require you to install the app before you either go to work or enter a restaurant. There are very strict limits to the way that data can be used by health professionals and where it's stored, etc. The flip side, though, is that the government did engage in a very extensive promotional campaign when it was launched. And I know in South Africa, this will ring a bell, as in Australia. Sorry, in the UK, probably not so much. But the comparison was made between the COVID Safe app and sunscreen. And that in the same way that you would never go out into the sun without wearing sunscreen, you should never go out of your house without the COVID Safe app, was the line that the government pushed. The result of the COVID Safe app is only 17 cases where there has been tracing. And I think this puts into context that there must always be a balancing of the pros and cons, that people will accept some either loss of privacy or constraints on the way in which their data is used, as long as there is actually a benefit that comes from it. And there were always concerns with this app, and as it has turned out, it hasn't been very effective. And so that sort of undermines the contract, if you like, the sort of privacy contract that people are entering into. But on to the points about data protection. In Australia, we have our competition and consumer regulator has been very active in this area as well. We're a bit behind the CMA on the report about ad tech, the use of data in ad tech. That is coming. What the ACCC has done is to look more at the consumer protection side. And as I mentioned, we have quite well established and strict laws on misleading or deceptive conduct. The ACCC has taken 2 cases against Google about the disclosures and the description of consents. There was one that was commenced in November last year about location data. And essentially the problem here in very broad terms was that there were various options within Android to change the way in which location data was collected. And whereas if you turned off the location data collection in one part of the operating system, it looked as though you had disabled it for all purposes. In fact, that wasn't the case. And so that sort of conflict between the controls, the ACCC has claimed, is itself misleading or deceptive. And in a second case that was commenced in July this year, and this refers more specifically to the case that Amelia raised, the claim is that the representations about enabling the combination of data from third-party sources by Google was misleading. And essentially there was a pop-up window that said to users, if you consent to this, if you click I agree here, then you will be able to have better control over the way that your data is used. What it didn't say was that if you did agree to that there was going to be combination of data in ways that hadn't previously been done, and in particular data coming in from third-party sources. There are a few other aspects to that, but it does show, I think, that there are cases where simple misleading or deceptive conduct laws can actually be quite effective to ensure that the consents given are appropriate. This, for Australia, the challenge that we have, and this is unlike South Africa and unlike the UK, is we don't actually have a constitutional right to privacy. There's no Bill of Rights in Australia, and so all of these topics are being debated from the ground up. It's something that is in some ways regrettable here, and it would be much better to come from a position where data protection and privacy is ingrained in the Constitution and accepted as a fundamental right.
All right, thanks for that. I don't want us to drift too much into digital economy considerations, because I think that we want to just bring us back to some reflections around regulators' role, in our regulators' role, i.e. the competition agencies and maybe the Consumer Commission in regulating pricing and perhaps stockpiling conduct. So Tizzy, just coming back to you on this issue about it is a data protection debate, but it dovetails to some extent with what the Consumer Commission has responsibility for in relation to direct marketing. And as David has said, misconduct rules or any kind of misleading rules. Do you think that you and the information regulator would have some concurrency in respect of these kinds of matters, or is there some kind of different standard between information regulator and yourself that is applied?
We really are, in this instance in South Africa, complementing also each other in this area. Though the information regulator is dealing with the processing of information, our role is to ensure that when people are marketing goods to consumers, there is a time frame, there is a curfew that has been put in place to say that can market to a consumer at this particular time. And then we also have the issue of false, misleading, and deceptive representation, wherein now we had seen this even more often, wherein we saw that when you're looking at the platforms themselves, especially when you're looking at the digital economy, is that the platforms were not clear in relation to whether they are the direct suppliers or somebody is a supplier somewhere else. But what we had also picked up as well is that though, as Amelia and David had said, is that the volunteering of information or maybe the education that we did not have as consumers when we are interacting within the digital economy, wherein now, in terms of the Consumer Protection Act, the onus lies on the consumer to ensure that if they are transacting, especially online, there should be certain disclosures or certain things that they should be looking for, like whether there is a return address of the supplier, is there the supplier acting in the ordinary course of business? Because what we had picked up with this misleading information is that, especially on social media, wherein people would just sell a sanitizer only to find that that person is not a supplier. We could not. So we had a lot of those complaints that we looked at wherein we could not follow through because there was no business address and all that in terms of just due diligence. So what we had picked up was the issue of education, but also as well is again, when we were looking at the payment gateways, to say that were we well prepared to understand what we were up for when we volunteer that information, because I think after that, we had a number of consumers that have been scanned because they volunteered that information. So for us as well is that as a consumer commission, the relationship that we have with the information regulator is wherein we start and end is wherein they take up. Because for us, it's only during those specific times and what we should be saying when you are marketing. But for them is that when you have that information, what do you do with it? So for us as a commission is that really we need to have a lot of advocacy and education and awareness for our consumers to make sure that when they interact in these platforms, they do not volunteer information unnecessarily and make themselves vulnerable. Thank you.
Thank you, Tezi. So one can see that, of course, there's a lot of, I wouldn't want to say convergence in the sense of perhaps what was contemplated by the person who planned the plenary, but certainly a multi-pronged approach that is required, because on the one hand, Tezi, your Consumer Protection Act comes at the problem from a particular angle. The competition agencies come at it from the pricing angle, and CISWE comes at it from a protection of data and personal information angle, which of course all must act together to ensure that one has a coherent response to the pandemic. But let me pause there and see, I've got a few minutes still, whether there are any questions from the audience. And I don't know if there are, and I can ask Songezo if we can, or Arthur, we can take some questions.
Yes, there actually are 3 questions, so I'm not sure who will direct them, but maybe let me read them and then you can decide who's best suited. So the first question is, what is an optimal strategy to protecting consumers in a disaster circumstance? The mix in South Africa was advocacy to national chains with a reputation to protect, raising consumer awareness, and some prosecution to deter business from gouging. Should the regulation have set maximum markups? That's the first question. The second question is, what responsibilities should online marketplaces have for third-party suppliers raising prices on their platform in the crisis? Then the last question is, should we be concerned about a post-COVID recruitment strategy for firms with market power that suffered some losses due to lockdowns? Those are all the questions from James Hodge.
Yes. Perhaps what we'll do is ask Amelia to kick off with the optimal strategy, given that CMA had quite an extensive one, and then allow the rest of the panelists to comment on it if needs be.
Well, I think that actually the CMA pretty much had an optimal strategy given the constraints that it was under, as I described. But I do think that there would be, as I said, merit in having specific law in this area. And the sorts of things that we were struggling with was we weren't really allowed to even ask for information, or we couldn't formally require information unless we actually opened a case, and opening a competition case is quite a big thing. So actually having better ability to send comply or explain letters to firms with a bit more legal basis and some requirement of information and expectation that they will respond. Maybe then restricting it to essential goods, but going to the question about whether they should be at markup, and this goes to David's point about the maximum markup. I think that does raise all sorts of concerns. So actually, and I'm not speaking for the CMA at all here, but how I would do it is actually set a price increase limit. So if you see price increase, you shouldn't be able to increase your price relative to past prices by say more than 50% or whatever percentage you come up with, 30%. I think that's how it's set up in the US versions of this law. And that doesn't say you can raise it by that much, but it says we would be very likely to bring a case against you if it raised by more than that or something like that. So you can set it to try and incentivize lower, but at least really stop the most extreme price increases. So I think that would have been a much easier, smoother, quicker tool to reach for that wouldn't have wide anti-competitive effects. And there is always these concerns that if you bring exploitative conduct cases, there are lots of concerns about they can actually distort behavior in terms of not allowing firms to, actually extract the full benefit of investments they've made, for example. So you can actually deter investment, etc. By keeping it really narrow, really specific to specific types of products and specific periods, I think a quite intrusive rule would have been justified.
Thanks, Amelia. David, Tezi, any comments on that? I mean, I think focus it on whether there should have been a maximum price or whether the approach of a maximum increase or markup would be a better one. Price control has got its pros and cons, and as earlier indicated by the commissioner, that one didn't want to discourage supply, entry into supply of these products by controlling price. But on the other hand, you have this difficulty of an excessive price. David, have you got any comments or experiences from Australia on this?
Look, I think first of all, the experience with our determination has not been great because I understand there hasn't been any action taken under it. So there is a problem if you set the rules as too restrictive, then actually enforcing those can raise a different set of issues. I agree absolutely with Amelia and the US approaches where there are, in response to natural disasters and so on, those limits on the sort of speeding tickets, if you like, the extent to which the prices can be increased. The other, I think, in direct answer to James's question, what is the optimal strategy to protecting consumers? I think we've all seen in our own ways that whatever that is, it's unlikely to happen in the middle of a pandemic or a natural disaster. So it's maybe setting the bar a bit too high. But one thing that I think has been certainly effective here, it's very crude, but it does seem to work, is simply providing information about, cases of very high pricing and also what is a normal price will often allow people to make decisions and to ensure that the market then, starts providing the products again at a reasonable price based on competition.
Unless you have a burning comment, Tezi, I need to move us along because we've got 3 minutes left. Tezi?
Yes, I think from our side, I think what would definitely be best will be the issue of just leaving the market as is, though there is regulation, but let competition be there. And then also talk to the issue of justification of the increases, because the strategy that we had followed, if I were to be the minister and ask myself, what else would I do? I would definitely follow the same way of looking at the demand and supply and making sure that from both angles, one can justify, and especially looking at the prices, what the people were charging and what it is right now, and just going back and say, just justify that price increases in relation to your own business model. That seemed to work better because it still left a room of competition for companies to really compete. Because if you really set up a markup, that would mean that everybody will go to a maximum. If you say 20%, everybody would increase up to a 20%. But if you allow them to justify it, then the competition actually is still being exercised. Thank you.
Thank you, Tizzy. So there are two other questions, but what I want to deal with in the last 2 minutes is this very interesting one, which combines the discussions we've been having about platforms and online marketplaces. And the question from James is, what responsibility should online marketplaces have for third-party suppliers raising prices on their platform in the crisis? It sounds like a very moral answer that is going to come through, but I mean, do we have any recourse? Should we be placing any responsibilities to these online marketplaces for third-party price increases during a pandemic such as COVID-19? Maybe Amelia, you can go first, and David, and then Tizzy. And Silvia, just jump in if you need to.
Well, I guess we actually did, because we pointed these things out to Amazon and they did act. Whether we had a firm legal basis for that, I think is untested, but I think we did get some good outcomes, and I think if we had a better legal basis, that would be useful. The other thing that actually a lot of pressure was put on the platforms about was misleading advertising in relation to COVID cures and things like that, and I actually think that they did a pretty good job on that front, and I think that was there was, I don't quite know what the law was there either, but there was a clear moral imperative on them, and I think they reacted well.
Oh, thanks for that. David, of course, you come from the other side, but you can give us your own personal views rather than the views of your client, sometime client.
Sure, and I will just make that disclosure very clearly to anyone who didn't hear it before, that I do act for Amazon, so there's an interest there. Look, I suppose the main point, and it doesn't really matter whether I act or they're my own views, is that the platforms often have, they do have an interest in ensuring that these prices are not on their platforms, and so I agree with Amelia that and Amazon's experience in Australia was the same as in the UK, that they are fully on board to ensure that these sort of egregious prices are not there. The problem, of course, that the platforms face, as the regulators do, is what is a price that's too high. And we've seen in Germany that action was taken, that there's a potential, claim that by imposing a maximum price, that may itself could be interpreted as abusive conduct. And I suppose in some ways it's just a matter of working with the regulators to ensure that there won't be that sort of response. But look, I agree with that conclusion, that ideally you would have a firm legal basis so that the parties can go into it knowing what they have to comply with and what should be done, and if possible, how the maximum prices should be set.
Yes, and from my side, from the Consumer Commission, is that platforms actually, they are part of the value chain. Whatever rules that apply to an ordinary retailer of brick and mortar should be applying to a online platform. So whatever price that they set up, there should be disclosure to information so that the consumer would know what is the markup and all that. But then what is also essential as well is to really also be honest with the consumer to say, I am simply fulfilling and this is the seller, so that the consumer would also have a choice to say, do I really want to buy if this is the fulfiller and this is the seller, so that they can exercise their right to choose. Thank you.
Thank you. I think we've come to the end of a session. I'm not sure, Songezo, whether we have the luxury of any additional time. It is, according to my watch, 2 minutes past 3. But I thought I'll just give everybody 30 seconds, just a quick round, last comments, last thoughts, some important insight they might have gained just so that we have benefit of our panelists. And let me start in the other order. Tezi, you go. Everybody's going to get a 30 seconds a shot at making some closing remarks. So Tezi, the floor is yours.
Thank you very much. What we had to learn to really here is that we need all the regulators to act together. We don't need a separate law, because what we had learned is that while we are dealing with price gouging, we also dealt with issues of standards, wherein we needed the South African Bureau of Standards to on products that really were not within compulsory specifications to really test those goods. So for us is that when you are dealing with a abnormal situation like this, all the regulators have a place to play in relation to their mandate. And for us, it's not about only consumer protection, because consumer protection lies in the mandate of most regulators, and we need to, all of us, be in it together to have a holistic approach to protect consumers. Thank you.
Thank you, Tezi. David?
Look, I suppose the thing that strikes me is that we are probably only halfway through the COVID crisis. We've had the situation where there was, in some cases, a massive demand spike. And in many cases, and certainly in Australia, we have seen in areas like hand sanitizer, there's been a response from the market to that, or the supply side of the market to deal with that. What we're going to go into next is potentially a massive downturn in economies, and we'll see some of the other problems with crisis cartels that come up. So that, we should be attuned to that. I certainly agree with Tezi's comment that regulators do need to have an integrated approach, and wherever possible, I think, in the CMA case and to some extent in South Africa as well, that having integrated regulators is a very good outcome. But I suspect there's going to be plenty to talk about at next year's conference.
Thank you. Amelia, you had the last word.
So I think actually David's point is a really, really good one. I mean, I personally still think we should have a specific regulation. The UK response to the past price gouging has been sufficiently good and effective that we probably won't get that regulation in the UK because I don't think it's perceived that there is a big enough problem. However, I do think that we're now going to have major economic issues in most countries around the world, and that's going to lead to all sorts of new issues, including probably both on the competition side and the consumer side. So there's going to be need for the authorities that aren't already combined to work together really closely for the foreseeable.
Oh, thank you for that. I want to thank all of you, my panelists, for your participation. I want to thank the audience for bearing with us on the graveyard shift. And I want us to go away with these few learnings that it's going to get worse for us, because we are going to see the fallout of the economic recession as a result of this pandemic. And I'm sure we will be finding ourselves in very challenging merger situations and possibly recoupment of losses. So I want to thank you all very much, and good afternoon, and I hand over to Songezo.
Indeed, thank you very, very much, everybody, for your participation, for your engagement, for your audience. All 114 of you, you've done well, considering, as Yasmina said, this is the graveyard shift. Commiserations to you, David. You might celebrate the fact that the Springboks are not participating in this year's Nations Trophy. It becomes a Tri-Nations, gives them else an opportunity to win. But be very sure the William Webb Ellis Trophy is very much entrenched in Cape Town at SARU headquarters. Sis Nandi, you might want to introduce now the conference closing segment in introducing again a face that we all love, Commissioner Thembinkosi Bonagele.
All right, thank you very much, Songezo, for that. I'm going to now ask the Competition Commissioner, Mr. Thembinkosi Bonagele, to close the conference for us. Mr. Commissioner.
Thank you very much, Nandi. This is meant to be a very short segment. Of course, it's been quite an exciting 2 days for us, and it's very sad that is coming into an end. We've enjoyed the debates quite a lot. I personally have learned so much from all our speakers. And I'd like to thank all of them, panelists, the facilitators of the panels, or the chairs of the panels, the academic authors, as well as discussants. Really made our conference quite lively. I would like to also thank our counterparts from the tribunal, the chair of the tribunal, Mondo, who kindly ushered in into the conference with an opening address, as well as her colleagues who have collaborated with us in organizing the conference. I'd like to also thank the internal team of the Commission. This conference's content is driven by the chief economist of the Commission. So I'd like to thank James Hodge for putting together a wonderful program, as we have heard, but also the team from communications, which has helped organize. The team of Itebucheng, as usual, has delivered quite a fantastic conference from an organizational point of view. From communications, I have to make sure that everybody who participated is acknowledged, because they were really the drivers of this. So I wish to send a shout out to Lydia, Molefe, Sia, Makunga, and also we had a team that was working with James. I didn't get all their names, but I know that Jason has been doing so much to get the conference going. And we had Kanye also helping a lot with stakeholder engagements around the conference. I'd like, last but not least, to thank the technical team, the IT people who have made a virtual conference for the first time possible. I think they've done a fantastic job. And if it was a live conference, I would be saying, let's give them a standing ovation. And then I want to, on behalf of all of us, to acknowledge and really give a word of appreciation to Nandi and Songezo for steering us for the past 2 days. If I've left anybody and not thank, you will blame this too. But it's been a fantastic, one of the most fascinating versions of this conference. And I think we've learned a lot from holding it virtually. I suspect that we are going to hold on to some of the elements of this virtual conference. It's been exceedingly successful. It's been efficient. It's been less expensive. It's everything just worked according to plan. So I thank all of you who have also come to our conference this year. Our staff who have come in numbers, but also our audiences who came from all parts of the world, all the continents of the world. So thank you very much, and may you have a wonderful time. Enjoy the rest of the week and enjoy the December break. Thanks very much.